Adrian Saunders, President of the Caribbean Court of Justice, distinguished honorary judges of the CCJ, former judges of the CCJ and the Registrar of the CCJ, the Honorable Chief Justices, Court of Appeal Presidents and sitting and former members of the Judiciary, Court Registrars of the 16 member states comprising OCBA, members of the family of the late Honorable C. Dennis Morrison, Order of Jamaica, led by his wife, Mrs. Janet Morrison, and son, Mr. Simon Morrison, Mrs. Denise Kitson, King's Counsel, Chairperson of the General Legal Council of Jamaica, the Honorable Michael Hilton, OJK, King's Counsel, former Chairman of the General Legal Council of Jamaica, Attorneys General, Honorable Ministers of Government, Members of Parliament, Senators, all from the 16 member states comprising OCBA, the Directors of Public Prosecution from the 16 member states comprising OCBA, Mr. Peter Maynard, President of the Commonwealth Lawyers Association, members of OCBA, distinguished guests and invitees, colleagues, attorneys at law, friends, ladies and gentlemen. Good afternoon to all. My name is Donovan Walker, and I'm the president of OCBA. So on behalf of OCBA, the Organization of Commonwealth Caribbean Bar Associations, the General Legal Council, and the Caribbean Court of Justice, I welcome you all to the C. Dennis Morrison Memorial Distinguished Lecture. We are grateful that the Honorable Adrian Saunders, President of the Caribbean Court of Justice, will shortly be delivering a lecture to us entitled Celebrating Caribbean Jurisprudence, Intersections Between Law, Politics, and Society. The Honorable Justice C. Dennis Morrison was the excellent jurist, Caribbean man, and attorney at law. More important, he was a loving husband, father, brother, grandfather, teacher, and friend, a downright decent man, the lawyer's lawyer, the man's man, who never lost the common touch. Those of us who have had the benefit of his lectures in evidence or CLE seminars all marveled at his masterful legal pedagogy and his cool, calm delivery. He was the best lecturer that I had ever known. His advocacy was impeccable, ethical, and brilliant. His time on the bench filled with precedent-making, reasoned, and clear judgments. I was blessed to be one of his law partners for many years before he ascended to the bench. I'm blessed to be a law partner with his dear wife, Janet. Dennis would be pleased by this gathering, with over 850 attorneys at law registered from all over the Caribbean and beyond. He believed in regional integration, and the CCJ was an institution that he was so very proud of. And at OCBA, we are grateful for his service to OCBA and Caribbean jurisprudence over many years. So, as regards this lecture today, 5 housekeeping matters. Our program will see you shortly receiving greetings from our co-host, the General Legal Council of Jamaica, by Mrs. Denise Kitson, KC, followed by tributes to the Honorable Dennis Morrison, to be led by his son Simon Morrison and the family. Thereafter, the introduction of President Saunders by Mr. Ruggles Ferguson, KC. The distinguished president will deliver his lecture. And thereafter, the Honorable Michael Hilton, KC, will lead us through a discussion program with Q&A sessions. Ms. Sophia Choate will deliver the vote of thanks, and then Zita Barnwell, President of the St. Vincent Bar, and I will make closing remarks. We intend to keep this to 2 hours. The second thing, the LAT Zoom feed can only accommodate 1,000 persons. In addition to the LAT Zoom feed, attendees can watch this lecture program on UWITV online platforms. That is www.facebook.com/UWITV or www.uwitv.global. Just search in Google UWITV, you'll get to it. The third, we urge your participation. Those watching on the Zoom link, feel free to type your questions and comments in the chat. Those watching on UWITV online, or UWITV Facebook, you may type your questions and comments in the comment sections of those platforms. All attendees, the fourth thing, all attendees who made the request on the registration form will receive a certificate of participation and attendance from OCBA. OCBA will be making applications to the accrediting bodies for CLPD credits for this session as soon as possible during the course of this year. 5. UWITV has kindly agreed to make this lecture available for rebroadcast on its various platforms subject to their programming schedule. So I ask you all to sit back and enjoy the lecture. I now invite Mrs. Denise Kitson, King's Counsel, Chairperson of the General Legal Council of Jamaica, to add her words of welcome. Thank you very much.
Thank you so very much, Mr. Walker. My learned friends, all, and distinguished attendees, we in Jamaica, and indeed in the Caribbean region in general, delight in celebrating our heroes. We laud, honor, and idealize them as icons for their contribution to the construct of our societies, whether it be to our national, musical, cultural, or sporting development within the West Indies. In the law, the Honorable Mr. Justice Cecil Dennis Morrison, Order of Jamaica, Commander of the Order of Distinction, and former President of the Courts of Appeal in Jamaica, the Turks and Caicos Islands, and the Cayman Islands, and former Judge of the Court of Appeal of Belize, is such a hero, a giant of the legal profession. All of us here can speak to the fact that he touched our lives for good, and we will never forget his thoughtfulness, kindness, and humility. He was a leader at the bar in every sense, as a brilliant advocate and mentor of a myriad of young lawyers, having lectured and tutored generations of law students. He's known and revered throughout the region. Justice Morrison's contribution to the bench was as significant, if not greater. His judgments covered a wide range and were always erudite and incisive. His ability to communicate seemingly complex concepts of law was amazing, delivered in a lyrical style reflecting his love of literature, deservedly earning him the sobriquet linguist. Justice Morrison also served as a member of the General Legal Council of Jamaica, first as a representative of the bar, and later as the Chief Justice's nominee representing the judiciary. He chaired the Council's Continuing Legal Professional Development Committee through the early years of that program, and perhaps more importantly, he guided the Council's deliberations and development with the same strength he brought to the classroom, the bar, and the bench. A calm demeanor, engaging with a ready smile, and a polite but decisive response, reflecting his brilliant mind. On behalf of the General Legal Council of Jamaica, to which he gave so much, I am honored to welcome you all to the Cecil Dennis Morrison Memorial Lecture, hosted by the Organization of Commonwealth Caribbean Bar Associations, the General Legal Council, and the Caribbean Court of Justice, and thank the Honorable Mr. Justice Adrian Saunders, President of that court, for delivering what will no doubt be a presentation of excellence. I now wish to introduce you, particularly to those of you who don't know them, or him, Mr. Simon Morrison, the son of Justice Dennis Morrison, who, together with other family members and friends, will provide us with a more personal perspective of our late learned friend.
Thank you so much. And thanks to Akbar, the GLC, and the CCJ for convening this event in my father's memory. As you well know, and as has already been said, he held a deep commitment to regionalism, to the advancement of the legal profession and to legal education and legal academia. So this is a fitting and meaningful event. On a personal level, I should say that it sometimes feels as if we in the family share, a grief and memory of him with a great many people because of the degree to which he touched so many people. And so in a way, we are here now thinking of him with his extended family, for which I'm grateful. I have the pleasure and honor today of leading tributes to my father, which will be given by family, friends, and colleagues from the various roles he played in the legal profession. To begin with, I will invite my aunts, his sisters, Anthea and Petrona, to say a few words.
How to express in a few sentences something of what Dennis has meant in our family. So many words come to mind, and indeed we remain moved by all the words that were said on his passing, kind words lauding his intellectual achievements, his professional accomplishments, and probably even more important, words celebrating the caring human being he was. One thing is that I'll always remember his big-heartedness. And I can imagine him smiling at me quizzically, playfully, and asking, what kind of word is that anyhow? But he was so full of heart, so sensitive to the needs of family, friends, and indeed all those who made up his world. He was consistently generous, generous in word, generous in action, generous in spirit. As I think about early childhood, memory, and of course, family legend, because you don't always remember what you did when you were 4, memory takes me back to going with Dennis to the very first school we attended, which was in Christiana, where we lived at the time. We must have been 4 and 6, since the baby, my sister P.T., was still at home. My parents' account was that I was surprisingly serene for a childhood girl. Serene because I was certain that I was safe in the company of my big brother. Many memories intervene, but thinking back to teenage years, from teenage years and until the time when Dennis became a UWI student and we saw him not every day, I recall lively discussions on a range of subjects, which our parents encouraged because they clearly believed that children should be seen and also heard. So, of course, we didn't agree on all points, Dennis, P.T., and I, but we had to work very hard to resist the persuasion of his eloquence. He was our family wordsmith long before he became a lawyer. And we know why his friends named him linguist. I also remember his jokes and his exuberant sense of fun. That humor was, I think, linked not just to his incisive wit, but to a wish that he had to make sure that everybody felt okay, a wish that stayed with him all the years of his life. If he sensed that you were less than upbeat, he might tell one of his diverting tales, or he might tease. In fact, we teased each other often, all 3 of us, but there was never a sting. I thought of that one evening late last year when I had successfully completed the task of reversing up the steep driveway of Dennis and Janet's home in the hills. And I didn't need as close a direction as I usually did. And waiting at the gate, there was my brother. He gave me the sweetest smile and a joking thumbs up as if to say, wow, you improve. And we all laughed together, Petey, Dennis, and I, because Petey was there too. We laughed together as if we were children, teasing each other, because the truth is he got his driver's license not long after he was 17, and I was in a race to try and achieve that. And I got mine just before I was 18. In adulthood, this lightheartedness, the lightheartedness of his youth, became the quality that caused my son to describe Uncle Dennis as the life of the party, a title which was much more than an acknowledgement of his ease in social contexts. He was above all attentive to the mood and the situation of those around him. Tariq saw his uncle as an inspiration and valued his love and support. He remembers sharing patties and peanuts with Dennis on occasion when he picked him up at school. Tariq especially values the memory of receiving random text messages from his uncle, which he describes as messages of encouragement and upliftment. For example, simply saying out of the blue, "I'm proud of you." Dennis's enduring sense of fun was manifest in his interactions with the young. His roles as father and grandfather, and also as uncle, were, I think, precious to him. He delighted in the company of children, and they reciprocated that warm affection in full measure. Simon said memorably in his beautiful tribute at Dennis's funeral that his father was essentially an optimist, and I'm sure those who knew him agree. We remember, and I think his many friends and colleagues will remember, that in times of difficulty, he had the gift of being able to reassure. He had the gift of offering a needed word of comfort or of empathy. I will always remember my brother's qualities of fortitude and grace in times of challenge, in times of loss. As we face the challenge of making our way through the uncharted territory of his absence, we hold on to the memories and we give thanks for the blessing of the years shared with Dennis.
It's still very difficult to grasp that Dennis is no longer with us, because he was always there for us. One of my enduring memories of Dennis is his constancy. He was there for you in good times and in bad, celebrating your achievements and points of happiness, and also with you in the challenging times. I can remember when I had major surgery overseas, Dennis was not scheduled to join my mother and sister, but he arrived unexpectedly to be there. During our mother's several hospitalizations, he was always there, solidly providing support for family. He always supported us in our endeavors, big and small. Dennis was my big brother, and I was his little sister. No matter how old I was, when I became a senior citizen, he said that had serious implications for him, himself and Auntie, as I was the baby, the little sister. We used to have spirited discussions, sometimes on opposite sides of an issue. He would say I should be more objective, and I would say he should be less clinical. But we always agreed that nuance was of primary importance. Dennis loved to look at the stars and the moon, as did my sister and I. When there was a spectacular moon, he would phone or text us if we were looking at it, to ask us if we were looking at it, and we would do the same. I remember last year when Auntie and I were stuck in traffic and an amazing rainbow appeared. We immediately texted Dennis to ask if he was seeing it up in Irish Town, and he replied that he had, and that it was beautiful. I will always remember that.
Thank you for this.
Thank you, my aunts, Maggie and Petey. I will now invite his stepdaughters, my stepsisters, Giselle Gibson and Martine Scott, to say a few words.
Good afternoon, ladies and gentlemen. My name is Giselle Gibson, and this is my sister Martine Scott, affectionately called Chrissy, and we are Dennis's stepdaughters. Firstly, we'd like to take this opportunity to thank you for this chance to share reflections on our relationship with Dennis, who we affectionately call Dennis O. The gift that Dennis brought to our lives, which made him so absolutely intertwined with Chrissy and I, in the lives of our children, our husbands, our mother, was love. It was love mixed with kindness, mixed with patience, mixed with the joy of having us. Because love was at the forefront of his actions, with his Morrisonian charm, in no time at all, we were a blended family. And we were not his stepdaughters, but his daughters. As many of you will know and can attest to, humility was Dennis's thing. And I know he would blush at the thought of us professing publicly how amazing a parent he was. But I will say this about him. He was a busy man, a brilliant and a busy man with important business to attend to. But even with that, he had a maverick way of being truly present and making us know that we were important. And our question of the moment, whether it was about school, work, marriage, or haircut, was absolutely essential and worthy of his thoughtful consideration. Even when Mommy had long lost patience for the topic, he was there, looking with his gentle eyes, which said, "Tell me everything." Because of his patience and his calm manner, Chrissy would often say he was our only sane parent. Dennis was also an amazing grandparent to Bo, Nina, Emma, Parker, Lennon, and Miles. When my husband and I were unsure of our son's readiness for prep school at 3 years old, it was Dennis who took over and calmed our nerves. He took the school tour with all the parents. He met with the teachers, and he took Parker to his assessment. Dennis said when the teachers came to take Parker into the room for the assessment, Parker, infused with confidence from his grandpa, turned around and gave him a thumbs up before entering the room. And then Parker aced the exam. I personally know as a member of the Jamaican Bar that his willingness to share his time and knowledge was a distinguishing feature of his professional life. And many colleagues have shared with me over the years that they have benefited from his gentle, kind, and approachable way. I must say, this part of who he was is something I am incredibly proud of. I will also share that when Dennis was honored by the Jamaica Bar Association in 2020, in his acceptance speech, he shared, not for the first time, his passion for the CCJ becoming the apex court of appeal for Jamaica. As a son of the Caribbean, he knew we were more than intellectually capable of meeting the task of having a final appellate court for the Caribbean in the Caribbean. I share this sentiment here and hope to see it come to pass. To our sweet Dennis O, we miss you dearly. We think of you daily. We remember the many lessons and we pass them on to your grandchildren. Thank you.
It's Janet, Dennis's wife, my stepmother, to join.
Good evening, ladies and gentlemen, all protocol observed. It was Shakespeare in Julius Caesar who said, his life was gentle, and the elements so mixed in him that nature might stand up and say to all the world, this was a man. Dennis exuded gratitude. He was filled with hope. He was a man of strength demonstrated by his calm, peaceful, unruffled demeanor and his unforgettable walk. He was never in a rush. For us, left to follow, Dennis left an inspiring legacy of gratitude, hope, strength, and calmness. I wish to express my profound gratitude to Akbar for this recognition of my husband's life and career. I also wish to thank President Donovan Walker for staging this event in his honor. I also thank Mr. Justice Adrian Saunders for delivering this lecture in his honor. Dennis was among the batch of first graduates of the University of the West Indies Cave Hill Law Degree Program in 1973. Justice Saunders followed not so long after, in 1976. This made them both among the earliest graduates in the region of the University of West Indies degree program. They forged a common belief in the region's indigenous institutions, in the peoples of the Caribbean and their struggle to be self-reliant. They shared a friendship underpinned by mutual respect and affection. Dennis was a Caribbean man, this is well known, a regionalist, of this is well known. He had friends and colleagues throughout the region. I adopt all that has been said about his intellectual prowess before, but there is more. As an eloquent speaker, he was always in demand. He presented at several seminars and wrote many legal articles for the continuing legal education. The sessions were packed full of lawyers who wished to hear him shed light with ease and clarity on complex legal concepts. And so I confess, I used to try to get him to say this simple two-letter words, no. I even demonstrated to him how he should form his lips for the word no to come out instead of yes. Of course, he simply laughed at me. So I also confess that Dennis exhibited unparalleled intellect and was regarded among throughout his career as arguably the brightest of legal practitioners. While a student at Woolmer's Boys, his facility with the English language, already evident, earned him the moniker linguist, variations of which were Guai or Lingui. He was also familiarly called C. Dennis or simply CDM. To his beloved sisters, from whom you heard earlier, he was D-Boy. I often teased him and he teased me about calling each other darling in public, but today I unashamedly do so. During his many years tutoring at Norman Manor Law School, he encouraged law students to call him Dennis rather than Mr. Morrison or Sir. Many of you will recall this. Such was the easy connection he fostered with students. So we're here gathered today, his family represented by his son Simon, his adoring sisters Anthea and Petrona, his stepdaughters, Giselle and Chrissy, from all of whom you have already heard, to celebrate a loving, caring husband, father, stepfather, brother, uncle, and grandfather, while we also celebrate this giant of an intellect, a Caribbean man, a regionalist, for whom we all bear a lot of respect for his selfless contribution to the region for the benefit of all. I hate to differ from Mr. President Don, but I share yet another feature of his humility. He shied away from what he called a production. So, for example, what that meant was he didn't lack a fuss or focus about him or anything in connection with him. But today, my darling, indulge the production as your friends and colleagues honor your legacy, as we celebrate your contribution to the legal profession and its development throughout the region, as we show our gratitude for your devotion to learning, your scholarship, your brilliance, and the example of your generosity. We will hold your legacy in our hearts. Indeed, what a man. Till we meet again.
Janet. I will now turn to Audrey Wells, who over a decades-long friendship with my father was his student, his law partner, his colleague at the law school, and much more besides, to make a few remarks.
Thank you, Simon. The Honorable Mr. Justice Saunders, President of the Caribbean Court of Justice, members of the Morrison family, distinguished ladies and gentlemen. Little did I know that the tall, dark young man who greeted me by name when I came through the doors of the Norman Manley Law School as a student in September 1980 was destined to become one of my closest and dearest friends. At the time, I had no idea who he was, much less why he knew my name, but I and my classmates soon discovered our good fortune. Dennis was to us then what he became to thousands of law students over the years, someone to admire for his breathtaking brilliance, effortless eloquence, artful pedagogy, and wicked sense of humor, as well as a mentor, a confidant, an encourager, and friend. In those early years, we were one of only 2 sets of students to have him among us as a full-time tutor for our entire law school sojourn. What a gift it was. We got to witness Dennis the thespian, who reenacted dying declarations on the floor of the lecture theatre and recounted evidence given in decided cases in any number of Caribbean accents. Good-natured bantering with Dennis over a hot beef patty lunch was a perfectly normal event. It was while I was still his student that astute members of law firms came knocking at Dennis's door. And after some soul searching, he accepted an offer from the firm then called Duncox and Orrit, now Duncox. Much later, I became his law partner at Duncox, and so can bear witness to Dennis, the loyal, firm man, both as leader and team player, the conscientious litigator of consummate skill and judgment, and the simply great human being whom I had come to know. On that note, it is no secret that Dennis retired the Boss of the Year trophy at Duncox and became Boss Emeritus. I suspect more to spare himself the embarrassment than to spare the rest of us our blushes. As you have heard from Janet, Dennis did not crave praise or attention, quite the opposite in fact. As life would have it, Dennis was still a course director at the Norman Manley Law School when I became a member of the full-time staff in 2007 and a tutor on his course. So we were, in a sense, back where we had started, and it was great fun. More seriously though, Dennis's devotion to the law school and to legal education was legendary. His association with the Council of Legal Education spanned over 40 years, starting with his being a member of the first class of law school graduates, then as a full-time tutor, followed by continuous service as an associate tutor, save for the period when he served as chairman of the council. He gave to this area of his life ceaseless generosity of time, talent, and tithe. It is said that the reward for good work is more work, and this was exemplified by Dennis's life. In addition to the numerous organizations that he served, he was every student's first choice as a presenter for their admission to the bar, and later as a reference for one application or another. Any letter from Dennis, and yes, even a letter turning down your job application to the firm, was a literary treasure of poetic prose. Dennis was my close friend for over 40 years. He became, during that time, a much-loved member of my family, a friend to my husband and parents, a treasured uncle and godparent to my children, We could count on him for anything that it was in his power to give, whether it was just his presence, irrespective of where in the world that presence might be required. His counsel, manual labor, transportation to the airport at ungodly hours, you name it, he could be relied upon. And truth be told, got quite annoyed if you did not ask. His other close friends recount the same experience, and the mystery remains how he managed to do it all. We all miss him terribly, but are also so very proud of him. It is fitting that Akbar should honor Dennis in this way. He was as much in his heart, mind, and soul a son of the Caribbean as of Jamaica. He loved the region and its people. He seemed to have almost as many friends across his territories as he did at home, and was always eager to contribute to institution and nation building in any way he could. We in the Caribbean have said farewell to a great man. May we continue to honor him by our own lives and service in any way that we can. Thank you.
Thank you. And finally, let me invite the Honorable Mr. Justice Patrick Brooks, who sat on the Court of Appeal with my father for 8 years and succeeded him as president, to make some remarks.
Thanks very much, Simon. Good afternoon, ladies and gentlemen. I respectfully adopt President Walker's order of protocol. But before proceeding, I wish to say I feel very honored to have been included as part of this groundbreaking event. Jamaica and the Caribbean have undoubtedly produced some eminent legal luminaries, both from the bar and the bench. These have achieved national and international acclaim. However, I make bold to say that none has equaled the breadth of influence that our brother, the late Honorable Cecil Dennis Harrington Morrison, OJCD, has achieved. He effortlessly blended academic brilliance, diligence, gentleness, calm, humility, and class. The result was a true gentleman, a colleague and a friend anyone would be blessed to have. Much has been said, and no doubt will be said, about those qualities and his high academic and professional achievements. So please allow me a personal approach that I will term my journey with Dennis Morrison, with which I am confident many in this audience will identify. I first heard about Dennis Morrison on the evening that I landed in Barbados to pursue a Bachelor of Laws degree at Cave Hill campus of the University of West Indies. That evening, the chief hall porter at Sherlock Hall, the only hall at the time, his name was Tommy, hosted some of us newbies at his house. He regaled us with some stories of the great law students who had graduated just 2 years before. Chief among those mentioned were one Dennis Morrison and one Roy Fairclough, both Jamaicans who were respectively known by the monikers Linguist and Pharisee. Their brilliant academic achievements were preeminent in Tommy's presentation. However, some of the other reputed exploits are not for mixed audiences such as this. Over the 3 years of my sojourn at Cave Hill, the legends grew about these two worthies, and so many stories were told of their abilities and achievements. And by the time I attended Norman Manley Law School on the Mono campus, I would not have been surprised if I was told that they could walk on water. It was therefore with awe and astonishment that I came into personal contact with Mr. Dennis Morrison, who was fresh from completing his course of study at Oxford as a Rhodes Scholar and was to be one of our teachers. All his lectures had a full turnout of students. Those students who would possibly skip other lectures dutifully turned up for Dennis's classes and tutorials. His ease of address, facility with the language, and ability to make topics understandable justified the reputation that he had left at Cave Hill. On top of that, he was to use the language of the day, grounds, meaning down to earth. He was, hands down, my class's favorite teacher. We would see him at parties and be his guest at his home. It was a joy to be in his presence in any forum, as he made you feel comfortable. Fast forward to my professional association with Dennis as a colleague attorney at law. I will just, for the ease of ensuring keeping within the time, I will share with you one. I had the privilege of briefing him in what I believe was his first appearance at the Privy Council in the case of Pitkin against Graham, which is reported certainly in All England reports, in which, as counsel, he brilliantly triumphed on behalf of my firm's client in what turned out to be an important Jamaican conveyancing law case. My next recollection that I will share is that when I was a judge of the Supreme Court of Jamaica, Dennis, by then a seasoned Queen's Counsel, and I had a chance meeting in the lobby area of the Supreme Court. He referred to a case in which the Court of Appeal had recently overturned one of my decisions. Dennis, with his trademark mischievous smile, said, "Judge, I think you are righter than the Court of Appeal." That word of encouragement from my hero buoyed me that day and for many moments thereafter, especially as his words proved prophetic when the Privy Council supported my position in that case. As a judge of the Court of Appeal of Jamaica and later its president, Honorable Mr. Justice C. Dennis Morrison, CDOJ, was an innovator and leader. As my senior colleague at the court, he was welcoming, encouraging, and resourceful. He became my mentor at that level, as he was for other appellate judges. He was an exemplar of not only impressive clinical approach to appellate work, but also of judicial temperament. He was calm and confident and made litigants and their legal representatives feel comfortable. It was as his colleague at the Court of Appeal that I saw close up his deep humanity. A handwritten note of encouragement, sympathy, or congratulations, depending on the occasion, was one of his trademark ways of reaching out to colleagues and others. Members of staff at the court would seek him out for assistance and guidance. None was ever turned away unsatisfied. Among his achievements as an administrator at the court were that he initiated the standardization of the format of written judgments in the court. He introduced the concept of neutral citations, which was already being used by some other courts. As president, he brought together various stakeholders of the Court of Appeal in a court users committee. That committee provided a forum for the court's management team to share its plans and needs with members of the bar and other courts and receive feedback from each group. When I succeeded him as president of the court, especially in the early days, in any unusual situation that I faced, my mantra would be, how would Dennis approach this? These few examples are just the tip of the iceberg of why I held Dennis in such high esteem. The enviable qualities that this giant of a man possessed were an inspiration to me. I benefited tremendously from his friendship. The legal profession of Jamaica, and indeed the Caribbean, has also benefited tremendously from this legal luminary. His family, friends, and acquaintances have been given an example of what a genuine, caring human being should be. All are better for him having touched our lives. I thank the Organization of Commonwealth Caribbean Bar Associations for having taken this initiative to honor this truly great lawyer, jurist, and human being. Thank you very much.
Thanks, Justice Brooks. As is evident, we could pass many hours here reflecting on my father and his legacy. But after all, we do have a lecture to get to. So I will leave things here by saying again how appreciative I am that we're hosting this event. It's a great pleasure to reflect and to hear the reflections of others on his legacy and on who he was, and we will continue to carry him with us. With that, I will pass to the President of ACBA, Don Walker, to carry on with the proceedings.
Thank you very much, Simon, and the members of the Morrison family, led by you, Simon, and Janet Morrison. We really appreciate and love Dennis, his work, his contributions to Caribbean jurisprudence is legendary. And so on behalf of ACBA, the JLC, and the CCJ, I just presented this commissioned work to Janet Morrison for the Morrison family. It's inscribed, presented to the Morrison family on the occasion of the delivery of the C. Dennis Morrison Distinguished Lecture by President Adrian Saunders of the Caribbean Court of Justice from ACBA, the GLC, and the CCJ, 26 November 2024. Thanks again, Simon, and wishing for the Morrison family a wonderful holiday Christmas season. So thank you all. I'm now going to hand over to Grenada, to my friend Ruggles Ferguson, King's Counsel, immediate past president of ACBA, to introduce President Saunders. Ruggles, over to you, my friend.
Yes, thank you, President Don. And the pleasure and privilege is mine to introduce the guest speaker for this evening's lecture. In fact, a speaker who needs no introduction, but for the formality of it, I will discharge my function. Justice Saunders is a true Caribbean man. He's a graduate of the University of the West Indies, Faculty of Law, 1975 graduate. A graduate of the Hugh Wooden Law School, 1977 graduate. One of the early graduates of our Caribbean law schools. And from 1977, when he was admitted to the bar in his native St. Vincent and the Grenadines, for the next 19 years, he served in private practice, in fact, establishing his own firm, Saunders and Huggins, in 1990. After 19 years of private practice, he was elevated to the High Court bench of the Eastern Caribbean Supreme Court in 1996. And from then to the present day, there has been no turning back for Justice Saunders. In fact, for the last 28 consecutive years of this youthful looking man, he has been on the bench. In fact, when you do the calculations, I myself was taken aback to realize he has served the legal profession for the last 47 years, 28 of which he served on the bench in various capacities and at various levels. In May 2003, he was elevated to the Court of Appeal of the Eastern Caribbean Supreme Court. And shortly thereafter, in 2004, he was appointed acting Chief Justice of the Eastern Caribbean Supreme Court. And that's between 2004 to 2005. But as we know him to be, he has not just sat on the bench, heard matters, and delivered judgments. He has been actively involved in judicial reform, starting from the Eastern Caribbean Supreme Court up to this very day. In fact, in the Eastern Caribbean Supreme Court, he was the chairman of a very active judicial education institute. And it was that institute and his own involvement in that period led to mediation during his period as acting Chief Justice, the introduction of mediation, which has been a success story, one of the great success stories in the Eastern Caribbean, introduced in 2004. And he was also one of the leaders behind the development of the court's first judicial code of ethics. In fact, he has been actively involved in judicial integrity and the work in that field, and actually he serves on the advisory board of the Global Judicial Integrity Network. It's an appointment by the United Nations Office on Drugs and Crime global program for the implementation of the Doha Declaration. Justice Saunders, in fact, from the Eastern Caribbean Supreme Court bench, went straight on to the CCJ bench. In fact, was one of the founding judges of the CCJ in April 2005. Was among the first cohort of judges, and in fact seems to be the last man standing from those early appointments in 2005. Believe it or not, he has been serving on the Apex Court for the last 19 years. And the court itself will be celebrating its 20th anniversary in April 2005, which will mark his own landmark, 20 years on the CCJ bench. He has the age to continue going and going. However, his appointment to the presidency of the CCJ in July 2018 allows him no more than 7 years sitting in that position. And many are surprised that he's actually due for retirement not too long from now in July 2025. However, retirement is not the kind of retirement we know for outstanding jurists like Justice Dennis Byron, former president of the CCJ, and Justice Saunders. Apart from his work on the bench, he has been actively involved in judicial education and leading right up from his work at the Eastern Caribbean Supreme Court. He serves as a director and has been so serving for over 20 years on the Commonwealth Judicial Education Institute and is one of the outstanding jurists responsible for the training of judges throughout the Commonwealth. He serves now as the third president of the Caribbean Court of Justice. Justice Saunders is also an outstanding writer, reflected not only in his judgments, but also a writer and editor. He is the consulting editor of the Caribbean Civil Court Practice, and he is also a co-author of Fundamentals of Caribbean Constitutional Law, a must must have text in your constitutional library if you do not have one as yet, but a book he co-authored with Professor Tracy Robinson of Jamaica. I think hearing all the accolades heaped on Justice Morrison, whom we celebrate and honor today, the selection of Justice Saunders, almost an automatic and unanimous selection, is no accident, since he shares many of the common characteristics with Justice Morrison, sorry, a close friend and colleague of his for many, many years. And those characteristics include, he's an intellectual giant, like Justice Morrison, a Caribbean legal icon, one who has never lost the common touch, notwithstanding his elevations over the years, rapidly, from a judge of the High Court of the Eastern Caribbean to now president of the Caribbean Court of Justice. He also carries that calm demeanor, is very engaging, and of course is known for his humility. He in fact is one of the judges known in the Eastern Caribbean from the very early practitioners who are just called to the bar, feel comfortable in appearing before him. It is Justice Saunders holds an honorary doctorate from the University of the West Indies, and he's also an honorary bencher of the Society of the Inner Temple. He also lectures part-time in constitutional law at the Faculty of Law, St. Augustine campus. And it certainly gives me great pleasure to introduce to you not just an outstanding jurist who possesses a great judicial mind, but also one who is a great administrator, a great organizer, indeed a transformative leader. My pleasure on behalf of OGBA to introduce to you Justice Adrian Saunders to deliver the third distinguished lecture of OGBA. Yes, may I introduce to you Justice Saunders. Thank you.
Thank you very much, Ruggles. Mrs. Janet Morrison, other members of the family of the late C. Dennis Morrison, esteemed colleagues. I wish first to congratulate OGBA for naming this lecture series in Dennis's honor. And it really is an extraordinary pleasure for me to have been invited, and an honor to deliver the inaugural one under that name. It's not uncommon to make hyperbolic statements about a deceased person so as to amplify deserved tribute to them. But those of us who knew Dennis well will know that none of the views that were expressed this evening about him falls into that category. One of the noble things about the legal profession is that we eulogize our heroes when they are alive and in their presence. And much of what was said about Dennis, and much of what I will say now, was shared at the sit-in in honor of his retirement, in his presence and in the presence of his dear wife, Janet, and their children. As you heard, Dennis was in the first batch that studied law at the University of the West Indies. And that first class comprised truly outstanding luminaries. I think of Francis Alexis, Keith Sobion, Eileen Boxill, Justin Simon, Parnell Campbell, Roy Fairclough, Henry Brown, Hilford de Turville, Tapley Seaton, Sandra Mason, Andrew Cummins, Endell Thomas, and many others whose names now elude me, and who have all made their mark in defining and advancing our Caribbean jurisprudence. Dennis was the finest mind of them all, and unsurprisingly, he topped the class. I entered Cave Hill when that first batch was in their final year, and so we overlapped for 1 year. It was evident to me then that everyone on campus knew and admired Linguist, as he was fondly called. Over the years, I was very fortunate to have enjoyed an excellent professional and personal relationship with him, especially in the latter years. He appeared before me once as counsel in Anguilla. He was as scintillating as ever. Unfortunately for his clients, I preferred the case of the other side, ably presented by Alan Alexander. Dennis and I taught together at the CJEI's intensive study program for Commonwealth judges in Halifax. When I was appointed president of the Caribbean Court of Justice, he was then a member of the Regional Judicial and Legal Services Commission. And I was truly blessed to be able to call on his skills and experience to assist the commission and me in discharging our responsibilities. He was my go-to person whenever I needed to discuss a personal ethical dilemma or get a second opinion on a knotty issue. With his rare combination of academic and professional excellence, his easy way with people, his modesty, Dennis could have been anything he wanted to be. The world was at his feet. After a very successful private practice, he ultimately chose public service as a judge. Now, I've never spoken with him or his dear wife Janet about this, but I would not at all be surprised if the major political parties in Jamaica were not extremely keen to enlist him into their ranks. He would have been a prized catch. The electorate would surely have loved him. He would have quickly moved through the ranks of the party and ultimately become Prime Minister of Jamaica. Perhaps if that was his destiny, he would have made an even greater contribution to Jamaica and the region than he otherwise did. Maybe not. The tough compromises politics often requires one to make might have blunted his edge. It's nice to speculate, but we will never know. He chose to remain in our realm and became president of the Jamaica Court of Appeal, and after his retirement, president of the Court of Appeal of the Turks and Caicos Islands. He also sat in Belize, the Cayman Islands, and in several islands of the Eastern Caribbean. Perhaps only Telford Georges, another of my heroes, has sat in as many different Caribbean jurisdictions as Dennis did. I repeat what I said at the sit-in held in his honor when he retired as president of the Court of Appeal of Jamaica a few years ago. Jamaica has every right to be justly proud of and to revere this most distinguished son of that country. Equally, we in the rest of the Caribbean feel entitled also to claim him as one of ours. His service to the entire region has been immeasurable and profound. Dennis embodied greatness, and greatness among us must appropriately be defined and recognized so that succeeding generations might learn about the heights of which we as a people are capable and to which we must continually aspire. Next year, we will mark 50 years since the University of the West Indies and the Council of Legal Education began unleashing locally assembled lawyers on the Caribbean public. Yes, I've taken a former Trinidadian epithet and turned it on its head. as a phrase of endearment. At the time when these Caribbean lawyers were being assembled, the region was in ferment. Some states had not long emerged from the colonial yoke. Some were wending their way towards independence. Internationally, liberation movements in Southern Africa had stepped up their armed fight for self-determination and an end to apartheid. Caribbean students strongly identified with these developments. We were not just interested in beating the books and passing the exams. I recall marching through the streets of Bridgetown in 1974 in support of African liberation, and also, on another occasion, going down to the Barbados Workers' Union Hall to listen, spellbound, to a riveting lecture by Walter Rodney. Experiences like these helped to shape my outlook on life and the lens through which I see and interpret reality, including the law. When my former CCJ colleague, Justice Duke Pollard, wrote a book in 2004 titled Closing the Circle of Independence, the book's title resonated with me. Just a few days ago, I addressed the region's judicial officers on that subject. Today, I would like to spend some time addressing lawyers on the same matter. Like Justice Pollard, it is my deeply held belief that pursuit of the goal of closing that circle of independence is fundamental to the optimal and authentic development of our Caribbean jurisprudence and to the manner in which our constitutions and our fundamental rights evolve over time. Although it has been over 20 years since Justice Pollard placed that goal, that dream, on the front burner, we are frustratingly merely inching our way towards achieving it. As I indicated in my address to the region's judges, for a group of people to realize a goal, especially a grand one, such as closing the circle of our independence, a shared narrative must be embraced. That is to say, we must have a structured and coherent understanding of the sequence and meaning of key historical events that are relevant to the goal and that place it in its proper perspective. A shared narrative contributes to building the unity of purpose that is required to realize the goal. It keeps us focused and it encourages us to overcome the inevitable obstacles we will encounter along the way. What is the narrative that surrounds this particular goal? The narrative begins, of course, with the pre-Columbian indigenous peoples. They were free to make their livelihood however they please, constrained only by the powerful forces of nature. No alien civilization limited or thwarted their aspirations. They were, in that sense, independent until they suffered a Holocaust, a genocide. This Holocaust was followed by the imposition of colonial rule, the enslavement and transshipment of Africans to the Americas, followed by the importation of cheap indentured labor from Asia. It was a brutal system devised with the sole purpose of enriching Europe, which it handsomely did, through maximum exploitation of human labor and the region's fertile natural resources. The system was justified by the construction of an ideology of racial superiority, the deeply felt scars of which, centuries later, are still very much in evidence. Throughout it all, the colonized people fought back. At the end of the 18th century, Toussaint's brave Haitians successfully revolted and established an independent state, Haiti, the first country to permanently abolish slavery and the slave trade. How dare they? Their descendants are still paying the price. David Rudder's lament resonates. A.T., I'm sorry. In the Anglophone Caribbean, an end to enslavement was finally achieved and indentureship ended. In the wake of the atrocities of the Second World War, colonized peoples benefited from and helped to shape carefully defined global rules that promoted principles of inalienable human rights, self-determination for the colonized, and an abhorrence of crimes against humanity. In the latter half of the 20th century, adult suffrage was won, and Caribbean mini-states finally emerged from the clutches of colonial domination. That is our narrative. And in this narrative, the grant of independence symbolized a break, a disjuncture, the chance of a new beginning for those Caribbean states able to proceed to self-determination. Independence presented an opportunity for Caribbean people to have control over their own constitutions and to enjoy the fundamental rights and freedoms laid out in that document. Rights which did not necessarily mirror common law liberties that had, bit by bit, been recognized by the colonizer. These constitutions were supposed to have ushered in a new order, in some ways similar to and reflecting the old order, but in important respects different from the old. So, for example, in this new order, Parliament was not the supreme authority. Sovereignty was distributed among three co-equal branches. The judicial branch was entrusted with the important role of reviewing acts of the legislature and the executive to ensure conformity with the Constitution. The courts were made responsible for protecting and guaranteeing the human rights of the citizenry, and they were also obliged to provide effective remedies to those who complained successfully about being denied any of those rights. Justice Pollard's simple point was that this conception of independence is not fully realized. There is still work to be done to complete it. Some territories have not proceeded to independence, and for some that have, the United Kingdom still retains and/or has been permitted to retain a level of continued influence over critical aspects of our law and justice sector. The most obvious such lingering imperial influence is overarching. It deeply affects the manner in which our constitution and laws are interpreted and how our common law evolves. It is, of course, the retention of the Privy Council as the final court of appeal, even after Caribbean governments have gone through the process of creating a suitable Caribbean alternative. Simeon McIntosh, the great Caribbean jurist, has argued forcefully and not unreasonably that our independence constitutions are not actually our own and that this affects their integrity. It is unnecessary here and now to enter that debate. What I stress today is that, notwithstanding McIntosh's argument, upon independence, a new constitutional and legal order was indeed created, albeit superimposed upon or affixed to and running in tandem with the old colonial order. A fundamental consequence of this duality is that rules and norms must exist for treating appropriately with the manner in which the new constitutional order addresses the laws that undergirded the old order. The instruments that ushered in the constitutions required that the old existing laws be suitably modified to be accommodated within the new paradigm of constitutional supremacy the dispersion of government, judicial review, and enforceable fundamental rights. Contradictorily, however, the text of the early constitutions of Jamaica, Trinidad and Tobago, Barbados, Guyana, and the Bahamas indicated that courts should preserve these existing laws from being held to be inconsistent with the human rights laid out in the constitutions. The issue that therefore arises is, how do courts resolve that contradiction if and when pre-independence laws of the old order are repugnant to the high ideals that underpin the new order? As early as 1975, one of our first batch graduates, Francis Alexis, noted and discussed this contradiction in an article in Public Law. He sensibly concluded that, and here I am paraphrasing him, to apply to the existing laws the modification clause in the instruments that ushered in the constitutions is to make those existing laws conform with the constitutions. To apply only the savings clause in the constitutions is to apply the existing laws replete with their repugnancy. His view was that, if anything, the clauses in the constitutive instruments was intended to control the one in the Constitution, but at the very least, both clauses should be read together. There are now two apex courts serving the Anglophone Caribbean. The Judicial Committee of the Privy Council, the JCPC, and the Caribbean Court of Justice, the CCJ. In one of its early cases, the CCJ instructed courts of appeal and trial courts whose appeals it hears that they must follow the jurisprudence laid down by the JCPC unless the CCJ has specifically departed from the same. My UE classmate, Dr. Leighton Jackson, has criticized the CCJ for constraining the courts below in this fashion, when, in his view, we should have been encouraging them to explore new possibilities. His is not an unreasonable viewpoint, although there are counter-arguments. Be that as it may, the CCJ has over the years mostly embraced the jurisprudence of the JCPC, except so far on this issue of the treatment of pre-independence laws, or existing laws as they are referred to in constitutions. On that issue, the views of the two courts have sharply diverged. The questions that intrigue me are these. To what extent, if at all, do the roots of that divergence spring from A, a fundamental difference in the narrative of independence embraced by the judges of each of the respective courts, and or B, the circumstance that the British judges are physically and emotionally detached from the region? The treatment of existing laws by the JCPC has an interesting history. From the early years of independence, it appeared that the British judges did not exactly share the idea that independence signaled or should be treated as any new beginning. The view was taken that in the spheres of law, justice, and legal interpretation, independence was mostly a seamless continuation of the old regime under a different flag and anthem, that the essence of the new constitutional order could and should be determined by reference to the content of the old. Start with the old to find the meaning of the new. Lord Devlin actually said in Nasrallah that the existing laws already embodied the most perfect statement of fundamental rights, and that no inconsistency with constitutionalized human rights was possible. In those early years, the Privy Council sometimes construed the meaning of a constitutionalized fundamental right so that it could accord with the common law, even if the right, borrowed as it was, not from England, but from the European Convention of Human Rights, or in the case of Trinidad and Tobago, from Canada, was on its face framed differently, and when applied, yielded a different result from that which was cognizable by the common law. That approach is markedly different from one that starts with the overarching ideals that prompted self-determination and which are generally contained in the preambles to the various constitutions, or an approach that has actual regard to the text of the fundamental rights and then works its way downward and backwards, tailoring or modifying existing laws so as to render them consistent with the new order. As the British judges came under the influence of Strasbourg jurisprudence, their conservative approach to interpretation of our constitutional rights shifted. The case of Minister and Home Affairs and Fisher, in which Lord Wilberforce called for a more generous interpretation of our fundamental rights, is usually regarded as emblematic of that paradigm shift. Ultimately, courts are charged with the obligation to do justice according to law. That is the oath judges take. Since law is the antithesis of arbitrariness, justice must be done within the framework of the law. The rule of law is foundational to the achievement of justice. Not infrequently, however, a gap emerges between the law and justice. How should we eliminate or narrow that gap? Common law judges have over the years developed well-recognized techniques. When interpreting law, judges use devices such as reading down or reading in, or judges may have resort either to strict and narrow interpretations of the law or to a generous interpretation. These accepted devices are deployed to ensure that law is aligned to a modern understanding of deeply rooted constitutional principles and with fundamental rights. In the narrative of independence that I embrace, after a former colony has become independent, with a constitution such as our Caribbean states have, logic dictates that these interpretative devices should be utilized to advance the new order, to privilege human rights, and to promote self-determination of the formerly colonized people. If it is tenable to read in or to read down a legal provision, whether contained in a constitution or a statute, in order to protect and to promote constitutionalized human rights or to advance self-determination, then that is what, in my view, a court must do. There was indeed a period between 1980 and 2004 when the JCPC itself seemed partial to this approach. During that period, the British judges specifically affirmed that derogations from constitutional rights and freedoms are ordinarily to be given strict and narrow rather than broad constructions. In the United Kingdom, Parliament is supreme. The courts have no power to modify or strike down an act of Parliament. Despite this, the judges of that country still unfailingly utilize these techniques of reading in and reading down in order to secure the rights of British citizens and to abide by the European Convention on Human Rights. Consider, for example, the House of Lords decision in R versus A number 2. It is unnecessary to delve into the details of the case. It was a situation where provisions in the UK's Youth Justice and Criminal Evidence Act 1999, when read literally, infringed Article 6 of the European Convention on Human Rights, which speaks to the right to a fair trial. In order to avoid a finding that the UK statute was incompatible with the convention, the House of Lords used the technique of reading down to interpret the relevant provisions of the UK Act in a way that could render its objectionable provisions compatible with the defendant's right to a fair trial under Article 6 of the Convention. An example of reading in is to be found in the case of Gaydon versus Godin Mendoza, where the House of Lords read words into the 1977 Rent Act so as to be able to construe that act in a way that extended tenancy rights to same-sex partners. Here again, the purpose of reading in was to ensure compliance with overarching human rights values. In that case, Article 14 of the Convention, which deals with anti-discrimination, and Article 8, which deals with the right to respect for home and family life. A similar approach should be taken by Caribbean courts to pre-independence or existing laws. How does the citizenry make sense of legal interpretation that suggests that our independence and our Republican constitutions intend that our courts are empowered to modify or render void post-independent statutes that infringe fundamental rights, but on the other hand, existing laws must be construed so as to defeat enjoyment of the same fundamental rights? In the noughties, the judges of the JCPC had to grapple with this precise issue: how to interpret constitutional savings clauses which purport on their face to exalt colonial or existing laws over the enjoyment of constitutionalized individual rights. There was a deep and even division among their lordships on the matter. One group, led by Lord Bingham, president of the court, vigorously supported the view that existing laws can and should be construed so as to advance human rights. The other group, led by Lord Hoffman, the next senior judge, robustly held fast to the view that doing this was not permitted by the constitutions. In the Trinidad and Tobago case of Rudall, a 3-2 JCPC majority determined that courts were indeed entitled to modify an existing colonial law, in that case one that prescribed the mandatory death penalty for murder, so as to have the law comply with that country's constitutional Bill of Rights. The Privy Council then decided to settle the vexed question by assembling a 9-member bench in 2004 to deal with the cases of Watson from Jamaica, Matthew from Trinidad and Tobago, and Boyce from Barbados. Lord Millet, a dissentient in Rudall, has written in his memoir, As in Memory Long, an alarming story about the circumstances involving the decision to ask former Jamaica Chief Justice Edward Zaka to comprise the 9th member of that panel. Those interested should read that memoir. At any rate, a bitterly divided Privy Council voted 5-4, with Sir Edward joining the Hoffman group, to reverse Rudall and to leave firmly in place a penalty that everyone accepted constituted cruel and inhumane punishment. Writing for the bare majority, Lord Hoffman claimed that if and when colonial laws were found to be inconsistent with the rights and freedoms that were declared in the Constitution, it was for Parliament to provide the remedy. The reality is that democratic governance in the Caribbean is not solely guided by the will of the legislature. Caribbean constitutions are not premised on parliamentary supremacy. In some constitutions, Parliament, even when it acts unanimously, is incapable of passing certain legislation without the support of the people in a popular referendum. In all our constitutions, responsibility for protecting the rights of the citizenry is specifically entrusted to the judiciary. Neither parliamentary inertia, for which there may be myriad explanations, nor parliamentary indifference to the deleterious consequences of an existing law provides, in my view, a justification for constitutional interpretation that precludes courts from affording effective remedies to persons affected by laws that trample on constitutionalized human rights. In a trilogy of cases, Nerves, McEwan, Bisram, the CCJ has agreed with the JCPC majority's 5-4 decision that general savings law clauses shut out the modification of existing laws that are or that have become inconsistent with a modern understanding of human rights. Caribbean narrative and indignation are evident in the CCJ's framing of its stance on the matter. At paragraph 58 of the CCJ's judgment in Nerves, CCJ majority stated that, and I quote, "The general savings clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the provision formed part of the inherited laws from the colonial regime must be condemned." Faced with the Nerves and later the McEwan CCJ judgments, the Judicial Committee of the Privy Council had an opportunity to reconsider its 2004 decision, giving due regard to the views of the CCJ, an apex court comprised of Caribbean judges who actually reside in the Caribbean. Another 9-member JCPC bench was convened in the Trinidadian case of Chandler. The issue in Chandler, as was the case in Watson, in Boyce, and in Matthew, was whether to modify the law prescribing automatic death sentences that everyone agreed were cruel and inhumane. No Caribbean judge sat on Chandler, and it would have made no difference this time if one had. The 9 British judges were unanimous. They conceded that although the CCJ's approach in Nerves was not unreasonable, Trinidad and Tobago's General Savings Clause should continue to be interpreted in a manner that would result in restricting the enjoyment of fundamental rights. And so, according to their lordships and ladyships, where 2 ways of resolving a legal issue are tenable, one having the ostensible effect of doing away with mandatory application of a cruel and inhumane punishment, and the other leaving that system in place, their lordships were satisfied to adopt the latter. In their view, the reasoning that supported the denial of human rights was sounder. They buttressed their views by resort to the principle of stare decisis. It was very important to them to adhere to their earlier 5-4 precedent, given the tremendous store they place on that principle. In support of their adherence to the principle, they cited the US Supreme Court in Planned Parenthood versus Casey, which judgment we know upheld Roe versus Wade in relation to the right to privacy and a woman's ability to access abortion services. The decision in Chandler, paying homage to stare decisis, was given in May 2022. The following month, in Dobbs against Jackson's Women Health Organization, the US Supreme Court spectacularly reneged on both Roe v. Wade and on Casey. So much for transatlantic reverence of precedent. The JCPC's Chandler decision on Trinidad's General Savings Clause was again endorsed in the case of Attorney General against Mirage. These decisions, Matthew, Chandler, Mirage, confirm a disappointing retreat from a stream of progressive Privy Council jurisprudence that flourished between 1980 and 2004, and that did much to advance Caribbean human rights. The retreat was actually presaged in the powerful 2004 joint dissent of Lords Bingham, Nichols, Steyn, and Walker that was entered in Matthew. It is useful to repeat what was said there by the dissentients because the sentiments they expressed are prescient, even more relevant today than they were when they were expressed 20 years ago. The dissentients commenced their attack on the reasoning of the Matthew majority led by Lord Hoffman in the following way, and I quote, "In recent years," of course that is prior to 2004, "in recent years, the Privy Council has generally shown itself to be an enlightened and forward-looking tribunal. It has, of course, recognized that the provisions of any constitution must be interpreted with care and respect, paying close attention to the terms of the constitution in question. But it has also brought to its task of constitutional adjudication a broader vision, recognizing that a legalistic and over-literal approach to interpretation may be quite inappropriate when seeking to give effect to the rights, values, and standards expressed in a constitution as these evolve over time. It is such an approach which Lord Wilberforce stigmatized in the phrase of Professor De Smith, which he made famous as the austerity of tabulated legalism. It is such an approach also which, in our opinion, vitiates the reasoning of the decision of the majority in this appeal. We consider the decision of the majority to be unsound in law and productive of grave injustice to a small but important class of people in Trinidad and Tobago. It is, in our opinion, clear that the interpretation of the 1976 Constitution of Trinidad and Tobago, which commends itself to the majority, does not ensure the protection of fundamental human rights and freedoms, degrades the dignity of the human person, and does not respect the rule of law. With much regret, but without doubt, we dissent from the majority decision," unquote. The respective appellants in the 2004 cases of Watson, Matthew, Boyce, and also in Chandler were all convicted criminals seeking to avoid automatic death penalties for murders for which they had been convicted. It would have been unfortunate enough if the precedent set by those cases concerned only the constitutionality of the mandatory death penalty for murder. But sadly, immunizing all pre-independence laws from human rights challenges goes well beyond affecting only convicted murderers. In Mirage, the immunity was applied in a case that addressed the constitutionality of the crime of sedition. And in the Guyanese case of McEwan, which was dealt with by the CCJ, the savings clause was unsuccessfully invoked before the CCJ, but if the attempt had succeeded, the clause would have preserved the sanctity of 19th century repressive laws that conditionally criminalized, among other things, cross-dressing, loitering, and public gatherings. Throughout various parts of the Anglophone Caribbean, colonial laws remain on the statute books that justify and reinforce a climate of intolerance of and even hostility towards the LGBTI+ community. Given that climate, Parliament is hardly likely to be the institution that will boldly rush in to protect the rights of persons who comprise that community. Legislatures tend to be unwilling or unable to address such contentious, controversial issues. The reasons are varied. Sufficient votes in the assembly may not be available. There may be deep-seated opposition from conservative or religious groups. Parliamentarians may simply fear political backlash. In circumstances such as these, members of parliament are often content for courts to take the heat by doing what courts are called to do without fear or favor, providing justice according to law. This has been the case in many countries. Here in the Caribbean, we have seen in recent times that judges throughout the region have been striking down sodomy laws enacted during the colonial period. See the cases of Caleb Orozco in Belize, Jason Jones in Trinidad and Tobago, Auden David in Antigua and Barbuda, Jamal Jeffers in St. Kitts and Nevis, McLean Ramirez in Barbados, and BG versus AG in Dominica. In states which retain a right of appeal to the Judicial Committee of the Privy Council and whose constitutions contain a general savings clause, the approach taken by the British judges to the manner in which constitutional savings clauses must be construed place these gains by the LGBT community in serious jeopardy. In many of the cases just mentioned, it is interesting to note that the state has declined to appeal. In the Trinidadian Jason Jones case, however, a decision on an appeal lodged with the Court of Appeal is pending, and each side has publicly made it clear that if they are dissatisfied with the Court of Appeal's decision, they will appeal further to the JCPC. If and when that occurs, it will be interesting to see how the matter is ultimately resolved there. In the Guyanese case of McEwan, which concerned a law dating back to 1893, which law, in these days of unisex clothing, outlawed cross-dressing, I noted that, in my judgment, judicial treatment of the constitutionality of that law, indeed of any law, cannot properly be divorced from the narrative that surrounds the law. To interpret the law, one must ask, why was it enacted in the first place? What interests did it serve at the time of its enactment? What interests does it currently serve? To answer these questions, we must often turn to historians and social scientists. I also stated then, and I continue to hold the view, that if interpretation of one part of the Constitution appears to produce an effect that obviously denies an individual their fundamental rights, then in interpreting the Constitution as a whole, courts should place a premium on affording the citizen her enjoyment of the fundamental right, unless there is some overriding public interest. This was the approach utilized by the CCJ in Joseph and Boyce when it was faced with a clause contained in the Barbados Constitution that purported to oust the court's jurisdiction from reviewing any and all decisions of the local mercy committee. In Joseph, the effect of the application of that clause would have collided with a man's right to protection of the law. No one disagrees with the view that parliaments in the region do have a critical role to play in addressing anomalies posed by general savings clauses and the debilitating effect on human rights these clauses can produce. The parliaments of Barbados, Guyana, and Jamaica, in substantial measure, have done this. It must be said, however, that pending any such parliamentary action, regrettable results accrue when courts tie their own hands by refraining from utilizing reading down devices. That approach will invariably place Caribbean states in breach of the American Convention on Human Rights and other international human rights instruments. Contrary to one of the great promises of our independence and republican constitutions, that approach robs litigants whose rights are clearly infringed of access to an effective remedy. It distorts the constitutional balance by neutering the role of the court in the protection of human rights, and it entrusts to Parliament a responsibility that constitutionally lies with the judiciary. Most significantly, when all the legal technicalities are set to one side, that approach feeds a narrative that colonial laws are sacrosanct because they were enacted by the colonizing power. The judgment of the Privy Council in the recent St. Lucia case of Hilaire versus Chasney strengthens that last point. A brief paper has been written on the implications of that decision by my former Court of Appeal colleague in the Eastern Caribbean, Mr. Michael Gordon, King's Counsel. I've taken the liberty here to borrow both from his analysis and also from the arguments of senior counsel, Mr. Anthony Astafan, who appeared as counsel before their lordships in that case. The brief background to the case is this. In 1956, when St. Lucia was still a colony, barely 5 years after there was adult suffrage in St. Lucia, that country's civil code was amended by the colonial authorities to insert Article 917A. The amendment came into force in 1957. According to this amendment, subject to certain provisions of the article, from and after the coming into operation of the amendment, quote, the law of England for the time being relating to contracts, quasi-contracts, and torts shall mutatis mutandis extend to St. Lucia, unquote. The question which arose for determination in Hilaire and Chasney was whether this provision immediately and automatically imported into independent St. Lucia, mutatis mutandis, every single statute enacted by the Westminster Parliament relating to contracts, quasi-contracts, and torts. Specifically, for the purpose of the particular litigation in issue, the question was whether the Defamation Act 2013 of the UK formed part of the law of St. Lucia by virtue of Article 917A. Senior counsel urged that this question should be addressed against the background that Article 917A was enacted not by the sovereign parliament of St. Lucia, but by the country's colonial legislature. Counsel argued that St. Lucia's 1979 independence constitution grants only to the St. Lucia Parliament the power to make laws for St. Lucia. The St. Lucia Constitution is supreme, and all laws inconsistent with it are void to the extent of the inconsistency. The Constitution stipulates how new laws are to be made. Among other things, as and when new laws are made, the same must be published in St. Lucia in a particular manner. Counsel submitted that Article 917A was an inconsistent provision, was a provision inconsistent with the Constitution, because if it were interpreted to mean that any act relating to contracts, quasi-contracts, and torts that was passed by the UK Parliament immediately and automatically formed part of the law of St. Lucia, this would result in the UK legislating extraterritorially for sovereign and independent St. Lucia without even seeking or obtaining the request or consent of St. Lucia. Counsel concluded that in all these circumstances, if Article 917A could not be suitably modified, it should be declared void to the extent of its inconsistency. The Privy Council dismissed each of these arguments as, to be fair, did the Court of Appeal of the Eastern Caribbean. The attitude of the JCPC to existing laws and to the manner in which those laws are to be construed in light of an independence constitution that is supreme is summed up in paragraph 18 of the judgment, which stated that, quote, the grant of independence to St. Lucia and the creation of a parliament within the newly created independent sovereign state could not, without more, have the effect of rendering invalid within the new state existing laws which had previously applied within the colony, unquote. What is particularly interesting about this case is that, for what it is worth, St. Lucia does not have embedded in its constitution a general savings clause as, for example, does Trinidad and Tobago. The reasoning in Hilaire and Chasney therefore goes well beyond Matthew and Chandler. Apparently, even without an applicable constitutional savings provision, the courts of a former colony may not render invalid colonial laws that are inconsistent with self-determination, that are inconsistent with international law, that are inconsistent with some of the most prized features of the country's supreme independence constitution. The laws of the former colonizer, the laws of the old order, however repugnant they are to the new legal order created by the Constitution, must remain in place until they are altered by the sovereign parliament of the independent state. I have heard it said that judges who embrace social context in their decision-making are politicians in robes, judicial activists unfaithful to proper legal interpretation. This has always been a profoundly misguided notion for me. Interpretation of a constitution is unlike interpretation of a contract entered into by private parties. Constitutional interpretation is a deeply contextual and practical exercise. Although it can involve abstract reasoning, it cannot be detached from the lived experience of those it affects. Apex court judges invariably make policy choices when interpreting a constitution. The choices made are conditioned by the values that spring from the Constitution's guiding principles. Those choices will be ineffective if they are not anchored in a philosophical understanding about societal values, or if they are unresponsive to societal needs. That is precisely why we utilize techniques like reading down and reading in, strict interpretation at times and generous interpretation at other times. Effective judges embrace, or at least are alive to the narrative, the aspirations, the social needs of the people whose disputes they try. When judges lack that appreciation, and worse, when that failing is compounded by the circumstance that the judges do not personally experience for themselves the real consequences of the decisions they make, there is likely to be a significant deficit in the decision-making process. It is this deficit, perhaps, that helps us to understand the profound contrast in the approach to constitutional interpretation we see displayed between the equally brilliant legal minds of, say, a Lord Hoffman in Matthew and a Telford Georges in Thornhill. I recently came across an article in the 1988 volume of Public Law, written by Justice Bertha Wilson. Justice Wilson was the first female judge ever appointed to the Canadian Supreme Court. Her article dealt with the implications of the passage of the Canadian 1982 Constitution Act. Among other things, that act allowed Canada to change its constitution without the consent of Britain. This is how her article begins, quote, "On April 17, 1982, Canada entered a new phase in the evolution of its constitution with the proclamation of the Constitution Act 1982. For the first time in our history, control over our constitution passed exclusively into the hands of Canadians, thereby marking the final step in our journey towards fully independent status as a nation," unquote. In the same way, Caribbean people must proudly strive for, quote, "control over our constitutions to pass exclusively into the hands of Caribbean people, thereby marking the final step in our journey towards fully independent status. The late Justice Duke Pollard, he says the same thing in different ways, in different words. He wanted to see us in the region complete the circle of our independence. The establishment of CARICOM and the entering into force of the revised Treaty of Chaguaramas, the creation of institutions like the University of the West Indies, the Council of Legal Education, the Caribbean Development Bank, and the Caribbean Examinations Council. These are all indispensable measures that have strengthened our ability to close that circle. We must nourish and treasure these initiatives. My understanding is that, commendably, steadfast moves are currently on the foot to replace the royal charter that governs the University of the West Indies with a regional treaty. In similar vein, the countries of the OECS must begin to give serious consideration to replacing with a regional treaty the 1967 statutory instrument that still governs the Eastern Caribbean Supreme Court. The establishment of the Caribbean Court of Justice is perhaps the greatest achievement of CARICOM, and the states of Barbados, Guyana, Belize, Dominica, and St. Lucia must be resoundingly complimented for acceding to the appellate jurisdiction of the court. On top of the fundamental reasons that justify that decision, the fact is that appealing to the Privy Council is so expensive an undertaking that persons of average means are dissuaded from appealing good arguable cases. When appeals to a final appellate court are choked off because people of ordinary means are unable to access their final court, the rule of law is compromised because important cases where the law is uncertain or is in need of review by an apex court are left unresolved or insufficiently addressed. There are many cases where the CCJ has heard disputes that in all likelihood would never have reached the Privy Council. These were cases that have made a profound contribution to clarifying the law and the constitutions of the respective states. The importance of delinking from the JCPC was recently underscored by the Chief Justice of the most populous state in CARICOM. According to the Gleaner newspaper, while addressing the Norman Manley Law School class of 1984, Chief Justice Brian Sykes questioned why a nation that has produced such strong figures of resistance and self-determination as Jamaica still clings to the colonial legacy of the United Kingdom-based Privy Council. The Chief Justice critically examined Jamaica's path towards decolonization, juxtaposing the accomplishments of the country's national heroes and heroines with the current political leadership's reluctance to fully embrace Caribbean sovereignty. So well said, Chief Justice Sykes. I wish also to commend ACBA and those constituent bar associations that have in the past supported this call. Completing the circle of our independence must be kept on ACBA's front burner and that of each individual bar association. It is, in my view, an aspiration that must be pursued relentlessly, right down to the end. The legal profession has an obligation to play a vital role in ennobling our Caribbean jurisprudence, in removing the barriers to full access to justice for all, and in promoting self-determination and the enjoyment of human rights. Let us not leave it to generations to come to complete the circle of our independence. Let us instead be proactive in fulfilling this role, lest succeeding generations consider ours to have been entirely remiss in our responsibilities. I thank you very much.
Thank you, President Saunders, for that excellent, thought-provoking presentation. You certainly covered a wide range of very important topics, not the least of which, of course, are the reasons why the many states in our region which do not now accede to the appellate jurisdiction should do so. But may I use moderator's privilege
to start off with one question. You ended by referring to a recent statement by Jamaica's Chief Justice. And as I'm sure you know, and other persons on the platform would know, there has been an ongoing debate in Jamaica on that issue. How do you answer, President Saunders, the persons in Jamaica who oppose that move with the criticism that CCJ judges could be described as judicial activists, a phrase you mentioned in your presentation and that you recognize as being one sometimes applied. There are opponents who apply that criticism to your court.
I'd rather be described as an activist than a pacifist when it comes to treating with laws that trample on human rights. If being a judicial activist describes a judge who seeks to ensure that the rights laid out in the country's fundamental law, the Constitution, are enjoyed by the people of the country, then I'm happy to be called an activist. I think that that is a role that judges should play. So it doesn't bother me that people refer to whether me or anyone else as a judicial activist. The point is, what is the role that is played by the court? And if that role is one which conduces to the enjoyment of fundamental rights, then so be it. Incidentally, the period between, as I pointed out in the lecture, 1980 and 2004, there was no more activist court than Judicial Committee of the Privy Council. And you go through the judgments. When they dealt with Pratt and Morgan, we always speak about Lord Wilberforce's judgment in Fisher. There's a whole stream of jurisprudence. But to be fair, maybe there were some people who called them activists at the time. But as I said, I'd rather be referred to as an activist than as a judge who allows the rights of the people to be trampled upon and not give decisions that will provide effective remedies for such persons.
Yeah, absolutely. Thank you, President. Colleagues, friends, the floor is open. If anyone has any questions, please enter them on one of the platforms. We will certainly put them to President Saunders. Oh, okay, I'm not seeing it. Jackie, please go ahead. Right.
She's not responding.
Okay, and it would be best, colleagues, if you wrote your questions in one of the chats, because we are monitoring them. One of the questions that has been asked, President Saunders, is why has the region been more progressive in its ruling around LGBT issues than the Privy Council? I think many people have found that surprising.
Why has the region been more progressive
Yes.
than the Privy Council? I don't know. One of the cases about reading down that I mentioned actually had to do with was it the House of Lords then? I think so. Going out of its way to read words into the UK's Rent Act to ensure that same-sex couples are able to enjoy the same rights as heterosexual couples under the Rent Act, so that it would appear that in relation to British citizens, the Privy Council, the House of Lords then, didn't have any qualms about ensuring conformity between the legislation of a parliament that is supreme with the European Convention. So this is why it would be very interesting to see how, if and when the case of Jason Jones gets up to the Privy Council, how they address that issue. But it certainly is something to ponder as to whether there is one kind of interpretation for British citizens and another kind of interpretation for persons who appeal to the Privy Council.
I mean, I suppose it could also be that to some extent the present composition of the Privy Council is a lot more conservative.
It is a lot more conservative today. That is true. That is absolutely true. And this is one of the things about the Privy Council which we should ponder upon. We are simply subject to the vagaries of how the wind blows. Not so long ago, there was a president of the Privy Council who was very concerned about all of these appeals coming for his judges to do. And he thought that Caribbean people should go to their own court rather than inundate his judges with these appeals, many of which didn't have much merit. Lord Phillips made those statements. Today you have a different view being suggested. On one occasion, you had a view being suggested that, well, this issue of Privy Council and Caribbean Court of Justice is not something that we judges of the Privy Council would like to enter upon. If countries wish to send their appeals to us, we are happy to do them. If they wish to go to their own court, then we're equally happy to see that happen. This is a matter which we are not going to get ourselves involved in. And then there are those who would write letters to the editor of the newspaper and seek to promote the Privy Council. So the point I'm making is that we have no agency over the direction in which the Privy Council goes. Maybe you might get a president next year who says, look, we're no longer happy to hear appeals from these countries. And we could do nothing about it. We just passively sit by and accept and meekly follow whatever is the marching orders or the line which is being carried by that court. We have no agency over it. It's not our court. They wake up one morning and they prescribe rules that limit our appeals. And, fortunately, on that last occasion that occurred, there was a concerted outcry about the rules, and they were withdrawn. But it certainly is a little odd that your final court is one over which you have no agency, no control. does what it has to do, and you simply march in step.
One of the questions being asked by an attendee, President, is a question that persons have mentioned in various arenas, which is, what is your response to critics who question the integrity and impartiality of judges of the CCJ?
Well, you see, you can't answer questions like that in the abstract. Where has there been an instance of lack of impartiality or lack of integrity? If they would condescend to indicate some instance, then you could respond to that. But
the court has been in being for almost 20 years, and I've never heard anybody question any of the judgments as having been subject to partiality.
It's very sad because that, there are persons who, listen, the judges of the CCJ are appointed on a very merit-based and competitive basis. We don't publish the names of the applicants, and there has been some concern that we don't. But we started to publish the number of applicants, the countries from which they come, whether male or female, both of those who have applied and those who are shortlisted. We don't even get that from the Privy Council, but persons accept, the judges of the Privy Council. No one questions their integrity, nor impartiality. And this is why it would be interesting for persons to read Lord Millet's memoir, as in memory long. I'm not going to repeat what he said, but I'm going to invite persons to read it and then come back and, make an assessment.
I confess I've not heard of that memoir. I will certainly look for it. President, there's a question that I find particularly interesting, and that is, for how much longer do you think the situation of two apex courts in the region can continue? Surely it will wreak havoc on a united jurisprudence and leads to views of one apex court overruling the other.
Well, that's a very good question. Just consider the Eastern Caribbean Supreme Court. This is a court that has responsibility for 6 independent territories. Let's discount the British Overseas Territories. It has responsibility for 6 independent territories. 2 of those territories send their appeals to the CCJ. And so when the Court of Appeal is deciding a matter, suppose it is a matter that has implications across the 6 territories. They are now faced with the dilemma that if in that matter, the Privy Council has one view and the CCJ has another view of circumnavigating that dichotomy. And it is not a very happy situation whatsoever. All of the countries that formally sent their appeals to the Privy Council outside of Mauritius have established their own courts. What is wrong with us? Why are we continuing to send our appeals to the Privy Council when we have gone through the trouble of establishing our own court? It really boggles the mind. But
this was more an observation than a question from a participant in Jamaica who comments that Jamaica faces a significant challenge in changing the public perception that judges closer to home are more susceptible to corruption or bias. It is an ongoing misconception that I know you've addressed, but as the writer comments, this contrasts the widely held belief that the Privy Council, due to its perceived distance, is less vulnerable to such pressures.
Yeah, again, you know, you can't answer those abstract questions, which unfortunately reflect the mind of the person posing the question more than any actual experience that has been observed by anyone. CCJ has been operating now for 20 years. And what anyone who has doubts should do is to ask the litigants and the lawyers who have appeared before the CCJ as to what has been their experience. That is the best way to assess the fitness for purpose of the court, rather than to stay outside and to project one's own fears and beliefs that might not be quite rational.
There's a question, President Saunders, that relates to the court's processes. And the question is, after about 20 years of the court's existence, is there any aspect of the court's processes which have been criticized or which you think should be reviewed?
No court is perfect. The CCJ is not a perfect court. And no court can ever be perfect. You always are struggling to stay ahead of the game. You always are seeking to ensure that your systems are in sync with what is required. In the area of our court administration, we have tried our level best to ensure that we provide for our court users modern technology. It's funny because when the CCJ began live streaming their cases, I read about it and commentators raved about it. We were doing that before them, but the innovations that are made by the CCJ are sometimes simply taken for granted. But when those innovations are done by other courts, people sit up and take notice. And it's an unfortunate part of the West Indian condition that happens. But there are areas in our operations that we need to strengthen. And as I say, we do our best, we do our best.
This is more a question from me, President. How do you assess the work and the operations of the Judicial Service Commission?
The work and operations of the
RJLSC, the Regional Judicial Service Commission.
I think that is a body that does not get enough. People do not sufficiently appreciate the hard work that is done by the commissioners and the largely successful work that they do. RDLSC commissioners give up their time voluntarily. They spend hours looking at and revising terms and conditions, addressing staff rules and regulations, ensuring that the best possible staff members are selected for the court, the best possible judges are selected. It's an arduous amount of work that they do. They publish an annual report, and persons can go in that report, and invariably you'll find that all the members attend all the meetings and all contribute. Our finances are overseen by a committee of the RJLSC. The administration of our pensions is overseen by a committee of the RJLSC. So it's a body that does a tremendous amount of work to ensure that the court achieves the highest standards.
And I think people often in our region often don't realize how independent that body is, how the members are chosen. And it's something that I'd really encourage people who don't know to check on the website and see that information, because it should really help to add to confidence in the court.
Exactly. And, you know, the commission about 2 years ago actually approved the code of, well, we tried to revisit and update our judicial code of conduct every 3 or 4 years. And on the last occasion, not only did we update the code of conduct, but the commission also published regulations so that any member of the public, and this is on our website, who wishes to complain about the conduct of a judge can lodge a complaint. So that when you hear about, you know, lack of integrity and this and that, you could lodge a complaint.
And there's a code of conduct that is published.
The code of conduct is published. And there are rules and regulations that indicate how a complaint must be addressed. So these are all mechanisms to ensure integrity. So that when you hear persons talking about, oh, the lack of integrity, make a complaint. If you have any allegation of the lack of integrity on the part of any judge, then there is scope for you to complain.
I'm reminded, President and colleagues, that we are running far behind. But I'm going to read 2 more questions to invite you, President, to address. One of them is by a member of the Jamaican judiciary, who asks, President, how do you react to the suggestion that the CCJ's decisions in Nervais by overruling the savings provision may cause parliamentarians in other jurisdictions to get nervous about the possibility of judicial overreach and therefore recoil from acceding to the appellate jurisdiction?
Nobody had that fear when the Privy Council said after 5 years you can't hang a man. There has been no more far-reaching decision than constitutional decision, than Pratt and Morgan. So what I find so frustrating is that people apply different standards to Caribbean institutions than they apply to other institutions, you know. We subscribe to a constitution. That is our fundamental law. The Constitution requires the courts to provide effective remedies for persons who, in the view of the courts, have had their human rights infringed. That is a responsibility that the courts must undertake. And Parliament has its role. If after the court has given a decision, it is possible for Parliament to change the law, and the change is in conformity with the Constitution, then Parliament is free to do that. So we each, Parliament, the executive, the judiciary, we each have our roles to play. And to suggest that a court or that courts should be looking over their shoulders when performing their role to assess whether, and if so, how would Parliament regard the work that the court does, is to be an ineffective court.
Yes.
Courts have to do what they have to do. Parliaments have to do what they have to do. As I pointed out in the lecture, we are not governed anymore by parliamentary sovereignty. We have a constitution that defines the role of each of the co-equal branches of government. And it is for the courts, like it is for the parliament, to perform their role with integrity and to the best of their ability. So when and I speak for myself, I'm embarked on an adjudicative exercise. I have to do what I think my conscience and my best understanding of the laws tell me that I should do. If that annoys Parliament, then unfortunately, so be it. They could pass a law that annuls that decision if that law is in keeping with the Constitution. So, that's how I see that.
A final question. One of our participants asked, why hasn't CARICOM as an organization not taken the step to force member states to accede to the CCJ as its final court?
Because each country is a sovereign country, and therefore each country has to take that decision itself. CARICOM could only do what they have done, establish the court, encourage states to subscribe to a treaty in which they pledge, they promise to accede to the court, as has been done, so that right now the states of Trinidad and Tobago and Jamaica are in breach of a treaty. They have executed a treaty in which they promised to accede to the appellate jurisdiction, and to date they have not. Well, that's on them, but CARICOM can't take unilateral action of that nature.
Thank you so much. And thank you so much for your presentation and addressing all these questions. Before I hand over to Vice President Shote, I'll just indicate a number of persons have asked whether your presentation will be available. And I'm told that it will be on the CCJ website as of tomorrow.
Yes, it will be.
Thank you. Well, I will now hand over to Vice President Shote.
Good afternoon, all. This event required a lot of planning and coordination involving many people and organizations to ensure that a lecture which is as important as this one has been given as wide a reach as possible. As such, my list of people to thank is quite long. But first of all, OCPO wishes to thank you, President Saunders, for what has been a riveting analysis of the interpretation of our constitutional growth in terms of the development of the policies of the judicial, the JCPC and its impact on our Caribbean jurisdictions or territories. We are constitutional democracies, and I think we have to agree that we must make choices as to our evolution. And I hope that having heard your lecture today, all our territories have been given food for thought and hopefully for growth. I want to especially thank you for your transparent and ethical explanation of judicial activism. As a lawyer, I am quite happy to hear a judge explain it to me, and to say that judicial activism is something which occurs within the context of fairness, impartiality, and the rule of law. I much prefer that as opposed to something hidden in the reactionary decisions of a former colonial power under the pretense that it doesn't happen. So thank you, sir, certainly for bringing that out and making it something that we can think about as we continue our constitutional journeys. In the spirit of regionalism, which Justice Morrison of blessed memory espoused, OCBA also wishes to express its gratitude to you, President Saunders, for your leadership of and contribution to the growth of the CCJ, which has become a powerful and respected regional organization. In this first quarter of the 21st century, the landscape in which judges have to perform their craft is changing rapidly, and this court, under your stewardship, has shown that it is prepared to meet its responsibilities to the citizens of the Caribbean. It is important for us to remember that the CCJ operates not only as an apex court, but it is also a court of original jurisdiction. This has been a true tribute to an eminent regional jurist by another, and we want to thank you for that. We thank the justices of the CCJ, the team from the CCJ which assisted OCBA in organizing this event, Ria Mohammed Pollard, Chelsea Dukey, Simone Jackson, and Registrar Gabrielle Figaro Jones. We are grateful for the very kind input of members of the Morrison family, led by Mrs. Janet Morrison and Simon Morrison, Patrona and Anthea Morrison, Giselle Gibson, and Martine Scott. We value your memories of the Honorable Judge. We thank Justice Patrick Brooks and Audrey Wells. OCBA thanks the General Legal Counsel, our co-hosts of Jamaica, the General Legal Counsel of Jamaica, our co-host, in particular its chairperson, Mrs. Denise Kitson Casey, Michael Hilton Casey, Tanya Farrell, Roisin Betton, and Donette McLean. We thank, as always, and I say so with some pride, the Council of the Law Association of Trinidad and Tobago and its president, Mrs. Lynette C. Bransweet, SC, for their continuing commitment and support of OCBA. In particular, we thank Rihanna Deusaran and Dave Mulchan Singh, who combined to make our events resounding successes. We thank all attendees for your patience, your attention, and your attendance today, and for your continuing support of OCBA. Thank you all.
Good evening, everyone. My name is Zita Barnwell, and I am here to give you some OCBA announcements. There are only 5 quick announcements. I'll make this quickly as we're running behind time. The first is that I'd like to remind everyone that we are about to publish our OCBA journal in December 2024. This is our 2nd publication for the year. And if you missed our June 2024 edition, kindly check our website or email us at secretaryocba@gmail.com so that we can send you a copy of that edition. We also want to thank you for your articles already submitted and welcome additional ones for the 2025 publication. Also like to use this opportunity to remind our respective bars to continue to update their subscriptions. We do apologize for not being able to provide payments by credit card and welcome your payment via traditional wire transfer or online wire transfer. Oh, I see Sophie still there, wasn't it? Okay, let me allow Vice President Shaw to continue.
Thank you so much, President.
Thank you.
Making your announce, you can finish your announcements, and then we'll try to replay the presentation. Thank you.
Thank you, President Walker. Yes, yes, thank you. So the second announcement is that we'd like to apologize for not being able to provide a facility for payments to be made via credit card and welcome your payments to be made via the traditional wire transfer or online wire transfer if your bank has that facility. The third announcement is that in May 2024, UWA signed a friendship agreement with the International Law and Immigration section of the California Bar Association. And this friendship agreement aims to foster and advance cross-border understanding, professional practice, and commitment to justice. The fourth announcement I'd like to make is that we'd like to encourage you to check out the Commonwealth Lawyers Association website to learn more about their 2025 annual conference. This conference will be held in Malta from 6th to the 10th of April 2025. And UWA congratulates all bars for successfully executing their Law Week and other legal education program in 2024. And we wish everyone a safe and joyous season and best wishes for 2025. And at this point, I turn you over to President Donovan Walker.
Thank you. Thank you very much, Zita, for those announcements. While we have a plaque that is to be presented to President Saunders at the CCJ by Sophia Choate. We're hoping that as soon as they're ready, they will turn on their video and make that presentation. But it may be that the presentation was not captured on video. And so what I'm wondering is if the team at the CCJ, as you know, I'm speaking from Jamaica. The lecture was given in Trinidad, and I'm wondering if the team at the CCJ, I'm sure you're hearing me, and is it possible to come on video and redo the presentation of the class?
Sure. Are you hearing me?
Yes. Yes.
Good.
Hi, President Saunders. Thanks again for your wonderful presentation. Sophia, over to you.
President Saunders, thank you so much for doing this lecture on behalf of UWA in honor of Justice Morrison.
Thank you so much. It certainly was my pleasure. Thank you. Thank you very much. And thanks to UWA.
Thank you both so very much, President Saunders. What a feast, what a wonderful lecture that you gave us this evening. I really want to thank you and the CCJ team for delivering as you did. As was indicated on the CCJ website, tomorrow the lecture will be available. So those who wish to get copies of the President's lecture a typed transcript of it. It will be available on the Caribbean Court of Justice website. We will be hosting lectures in 2025, the journal. We have a number of plans for 2025 involving all our regional stakeholders. And as we indicated earlier, we will be applying for CLPD accreditation, particularly in Jamaica and Grenada, where CLPD is now mandatory. The one thing that I will say to President Saunders is that ACBA remains committed to the CCJ being the region's final appellate court. And we have been advocating strongly in all 16 territories for this to happen. So ACBA remains firmly of the view that the CCJ is tried, tested, and proven. And I urge any persons who are still skeptical about it to do one of two things. First of all, to arrange to visit the CCJ whenever you're in Trinidad to see the operations of an excellent technologically driven apex court. And secondly, to read the article done by the Honorable Dr. Lloyd Barnett, OJ, I believe it is available online, where he did an analysis of the first years of the CCJ as an apex court. And he made some very reasoned conclusions as to why this court is no longer a neophyte court and certainly has the caliber and the quality of judicial clout and legal pedagogy to be an apex court that is excellent. And so we at ACBA certainly support the CCJ in that regard. It's just left for me to wish everyone a wonderful holiday season. This is the season of peace, and I urge all of you to have a wonderful holiday, a wonderful Christmas, whatever you celebrate and however you celebrate, to enjoy time with your families and friends. And we look forward to meeting with you again in 2025.
Before we close off,
yes, President.
Donovan, I want to just personally thank Mr. Green, Adam Green, our IT technician, who has been so patient with us and has sorted out all our technical issues here at the CCJ. So thank you, Adam.
And thank you for that, President Saunders. And again, on that, what I think the hundreds of people online need to realize, President Saunders, is that at the moment, I'm in Jamaica. We had participants in Grenada, in Washington, D.C., in Trinidad and Tobago, and various parts of Trinidad and Tobago and Jamaica. And we seamlessly were able to use the technology to bring us together. So, of course, I thank the CCJ IT team for doing that. And I really also have to again mention Rihanna Diosaran and Dave Mulchansing, who operated seamlessly from the LAT headquarters in Trinidad. And they really helped us pull this together, and kudos to them. Likewise, the CJ Bonady from UWITV and the UWITV team, those who are watching on Facebook and UWITV online, this really has been a collaborative effort and exemplifies regional excellence and what we can do as a region. We can learn together, grow together, analyze together, and maybe even disagree together using these platforms. So again, thank you all for coming. Have a wonderful holiday. Thank you again, President Saunders. And I believe that we can now formally end this C. Dennis Morrison Memorial Lecture. Have a good night, everyone.